The Secure Act 2.0 was passed as law at the end of 2022. There were dozens of provisions that change how you should be planning your retirement, and today we're going to cover what those biggest changes are so that you can incorporate them into your plan too. A few years ago, the first Secure Act was passed, and it changed the way that retirees were planning their futures. One of the biggest changes the first act brought was changing the RMD age from 70.5 to 72, as well as changing how beneficiaries had to treat their inherited accounts. Now the second iteration of the bill is here, and it creates even more changes that you need to incorporate in your plan. Whenever there are sweeping law changes like this, there's a period of time during which lawmakers have to clarify what they mean. In fact, we're still seeing this with the original Secure Act in some of the provisions. So with any of the changes that I discuss here today, just know that everything is still very fluid because it's a brand new law. Even the TSP website has notices about how they're keeping a close eye on this legislation so that they can understand what policies and procedures they need to change for the TSP going forward. This is going to be the same across all plan administrators as well. So let's jump right in. The first big change that we see in the Secure Act 2.0 is yet another change to the RMD age. Like I said earlier, the original changed it from 70.5 to 72, and now the new age for RMD starting immediately is 73 years old, later to be changed to 75 years old in the future. Now, if you were already 72 years old in 2022, then you're going to continue your RMDs as if nothing changed. This RMD change doesn't apply to you. Now, if you were turning 72 in 2023 and were planning on beginning to take your RMDs, you now have an extra year that you can wait before having to do that. But here's how you remember the whole thing put together. If you were born in 1950 or before, you are either on the 70.5 RMD age, which was the original, or this old 72 years old RMD age. If you were born in 1951 to 1959, your RMD age is now 73. And if you were born in 1960 or later, your RMD age is currently 75 years old. Now, the obvious result is retirees have a bit more time before they have to take their minimum distributions. But there are also some serious tax planning implications that you should be aware about. You see, when you first retire, you have what we call a tax planning window. When you're still working, you have years of high income, and of course that makes sense because you're earning a salary and all of that is being counted towards your taxable income. Well, the same is true for when you're required to take minimum distributions. Those are also years of high income. And this is because every distribution from traditional accounts counts towards your taxable income. But in between the years that you retire and when you have to start your minimum distributions, you have an opportunity of living on after-tax dollars, so these are things like savings or your non-retirement accounts, which means your tax bracket could be substantially lower for a few years. And that might give you an opportunity to utilize really helpful strategies such as Roth conversions and others. Now, it's important to know that your FERS pension is also going to be fully taxable, so you're not going to be starting from zero tax, but it will be substantially reduced than from when you were working. So the Secure Act 2.0 extends this tax planning window and gives you more time to implement these good strategies and help you reduce your overall lifetime tax liability. The next big change that's relevant to you is the fact that they've reduced the RMD penalty. Prior to this change, missing an RMD had a really steep penalty. It was 50% of the amount that you should have taken out. So for instance, if you needed to take out $20,000 for your RMD and you forgot, simply because maybe it was your first year and you didn't remember to do it, or you thought your spouse was taking care of it, or you thought your custodian was taking care of it, whatever reason, the penalty for not having taken that $20,000 RMD is $10,000. So this new law brings a nicer change and a breath of fresh air to reduce that to 25%, and it further reduces it to 10% if you correct your RMD within a certain time frame. Now, the next change you should be aware of is regarding Roth accounts. It was widely speculated that the backdoor Roth IRA was not going to be allowed anymore. It had been on the chop block several times here in Washington, D.C., and in fact, it was even part of the original bill, but it was removed once the bill was finalized. This is nice because it allows people that earn too much income to still be able to do Roth IRA contributions through the backdoor method. Now, the provision also allows self-employed people to make Roth SEP IRA and Roth Simple IRA contributions. So if you're a federal employee that has separated from service, maybe you're consulting now or you're starting a business, this can be a really great opportunity, especially in those early years, to put in tax-free money, or rather after-tax money into the Roth that gets to grow tax-free for your future. The other change also has to do with Roth, but as it relates to college education funds. For families that are trying to help their kids or their grandchildren by contributing to their educational funds, most people do it through what's called a 529 account. The challenge with a 529 account is that for any dollars that are not used for qualified educational expenses, they get penalized 10% of the balance. And what we see is sometimes kids are really successful in school or in sports and they get scholarships, and maybe they don't need all of the money inside the 529 account. Well, historically, you either had to use it for something qualified or you had to transfer it to another family member. But going forward, you're able to now move it to a Roth IRA in the name of the designated beneficiary. This is one of my favorite changes about this law, but there are some rules attached, so let's go through those and make sure that you understand them. The first is that you have to understand that the Roth IRA annual contribution limit still applies. So you can't just take a full $50,000 in a 529 that the child didn't use and put it in a Roth IRA. That doesn't work. The second is that there's also a $35,000 lifetime maximum amount that can go from 529 to the Roth IRA. And lastly, the designated beneficiary has to have earned income as defined by the IRS in order to qualify for the IRA contributions. Now, this is just like any IRA contribution. So if they have a summer job, for instance, that can qualify them for this. If they are working on campus, that can qualify them for this. The next big change has to do with spousal inheritances. But before we do that, if you found this helpful, will you hit the thumbs up and the like button for us? That really lets me know, and it lets the rest of the team know that this is the kind of content that you're interested in seeing and that you're curious about the Secure Act going forward. All right, so the spousal inheritance rules also changed slightly. Before, if you were inheriting the retirement assets of your deceased spouse, you could take it into your own account and take those assets on yourself. Then when you hit RMD age, it's calculated based off of your age. You could also take it into an inherited account. Now, the bill changed this so that you have more options, and it's especially beneficial if there is an age gap between the two spouses. Now, this particular part of the rule does not come into effect until 2024, so we still have one more year before it's in play. Under the new rules, you can still move it to your own retirement accounts subject to your own RMD, but you now also have the option of using your deceased spouse's age for the RMD calculation. Let me show you how this works. Let's assume we have a couple that's 65 years old and 70 years old, and the 65-year-old has $900,000 in their traditional retirement accounts, and the 70-year-old has $1 million in their accounts. And tragically, the 65-year-old passes away. Ordinarily, the 70-year-old would have to take the retirement assets of their late spouse in their name, and their RMD would actually be on the full $1.9 million once they turn now 73 years old for their RMDs. However, this new rule allows them to apply the RMD rules of their late spouse. So when this 70-year-old turns 73, the 65-year-old was only going to have been 68 years old to begin with if they were still alive. So that means that upon turning 73, only the $1 million gets calculated for their RMD, and the $900,000 still has 5 more years before it has an applicable RMD, because that was how far the age spread was from the beginning. Now, what this does is that it pushes back the time until all of the money has to be subject to RMDs. Remember, the higher the balance, the higher the RMD, and the more taxes you have to pay. So this creates even greater tax planning opportunities for someone in this position. Okay, the next change that's important is that IRA catch-up contributions have now changed. Historically, you'll recall that the catch-up contribution for an IRA was always a flat $1,000. You made the IRA contribution, and the catch-up amount for anyone over 50 was an additional $1,000. Well, going forward, it's now going to be adjusted for inflation in increments of 100. So for instance, the next catch-up contribution may be something like $1,100 or $1,200, $1,300. So just understand that going forward, the planning consideration is that you're not always going to make the same catch-up contribution. It may be more one year, less the other year, and so forth. Now let's talk a little bit about the TSP and some of the implications therein. The first big change is that RMDs for Roth work retirement accounts will no longer be applicable. You may already know that the TSP has traditional and a Roth, and if you have a balance inside the Roth and you are of RMD age, it will distribute the Roth component and count that towards your RMD as well. This is a ridiculous rule, and I've been talking about it for years that it should be eliminated, so I'm finally glad to see that it was brought into play. Now, again, to my point earlier, plan administrators need some time to start incorporating these new functions that the law introduces into the actual retirement plans. The new law also allows for participants to elect matching contributions to go into the Roth component instead of the traditional. So right now, in the TSP, even if you're doing Roth TSP contributions, your agency matches into the traditional TSP. Going forward, this law allows participants to make that election as soon as the payroll and administrators get that rule actually incorporated into the systems. The important thing to know here is that if you elect those matching contributions to go to Roth, you're going to be taxed on those matching contributions in the year that they go in. Just make sure that you're aware of this and you're not pushing yourself in a higher bracket than maybe you weren't anticipating. Additionally, starting in 2024, any catch-up contributions for people that make $145,000 or more must go into the Roth component of their retirement account if it's available. So this means if you are 50 and older, you're doing the catch-up contribution. If you make $145,000 and your catch-up amount now goes into the Roth, which means you're paying taxes on it the year that you put it in. So something to be aware about, and this changes the way you're going to incorporate your retirement plan projections and your overall tax planning. Then in 2025, the catch-up provisions are actually changing as well. So the first catch-up contribution can occur at your age 50 or older, but in 2025, age 60 is going to be an increase to the catch-up contribution amounts to the greater of either $10,000 or 150% of the catch-up contribution limits. So going back to my point earlier, if you're making $145,000 or more, catch-up contributions must go into the Roth, which means if you're doing the full $10,000 in catch-up contribution, that's a full $10,000 in additional taxable income that you're going to pay taxes on the year that you put it in. So you can see that there are a variety of changes that have come into play this year, and as time goes on, we're going to be creating more and more videos on how this plays out, how you should be implementing these in your retirement plan. So if you're not already subscribed, now is the time so you can join us for all of these videos in helping you plan a better retirement. And if you have questions about your retirement, if you have concerns and you want to learn more, visit our website. There's tons of resources there. Use the comment box below as this community grows. And until next time, stay wise and stay wealthy.